So Andrew, here today to talk about fees for intervention. Fees for intervention introduced back in 2012 by the HSE, October 2012. At that time introduced two reasons really. One, to generate an income stream for the HSE. Secondary reason was to obviously increase compliance, hopefully, throughout industry by having another mechanism by which people could feel a bit of pain. At that time, the HSE proposed or expected to bring in revenue of around about 43 million per year. Actually, in the 3 years that this has been running, they've now only invoiced 35 million, and out of that, they've only collected 26 million of that money. So way below the targets that they've set. How do you think that's going to affect the HSE's operation going forward?
So what I think we've seen are inspectors increasingly looking to charge for as much of their time as possible, finding material breaches where perhaps in the past they would otherwise have just given a bit of informal advice, that we're now seeing more letters written after a visit alleging a material breach and expecting the business to rectify and then to refund the HSE for their time. And I think given the figures you suggested about how successful they've been with recovering the money, we're going to see more of that in the future.
I think from our point of view, as a consultancy business supporting lots of businesses around the UK, we're certainly seeing, as you say, more appetite for material breach letters being written. And I think what that's leading to is a negative impact. Businesses are now less inclined to invite the HSE in to have a chat about a particular issue. And we've certainly seen in one case the HSE were invited in to have a look at something that the business thought were doing well and ended up in a situation where there was a material breach recognised, which I don't think is useful for anybody involved. Going forward then, what do we think businesses should be doing if they have a visit from the HSE regarding fees for intervention?
So I think if you're in the construction sector or in manufacturing, for example, that's where a lot of the inspections still take place. So if you're in those sectors, I think you need to expect a visit from the HSE sooner rather than later, and you need to expect them to be looking for a material breach. And so it's really important that as soon as the HSE arrive on site, be aware that although it might be a visit about one topic, they might branch off and look at absolutely everything. So be aware and be ready for that when they arrive. Engage in debate with the HSE. Don't be fearful about pushing back if you feel that what they've found or what they're commenting on is in fact okay and not a material breach. And be prepared to engage in argument with them or just debate with them as to how you need to be complying. And if possible, if there's something that can be fixed very quickly and very easily, then fix it there and then, because it reduces the amount of time spent on the issue and that will reduce the amount of the invoice.
I think the other interesting thing to mention really to close is this idea of a material breach. We could talk for hours about what a material breach is because even the HSE are finding it difficult to kind of define what that is. I think in summary, what they're saying is it is a legal contravention that they found. The difficulty then we've certainly identified is that if you get a letter, which is a fee for intervention, it's a civil matter, so it's not a fine, so they've got to collect it through a civil courts if you refuse to pay. But secondly, if you are a commercially minded organisation, you think, you know what, actually I'm not going to upset my enforcing agency, I'm simply going to pay the £500,000-600,000 fee. What is your advice to those businesses?
So I think there's a distinction to be drawn between the principle of whether something is a material breach or not and the commercial decision about whether to pay the invoice. There's a risk that payment of the invoice might be used in the future to argue that there was an acceptance that there was a material breach. So I think it's important, if you disagree, to write to the HSE to say we disagree that was a material breach and explain why. But then also say, if you've chosen to pay the invoice, that paying the invoice should not be taken as an admission that material breach had taken place. The other thing to do, of course, is to look carefully at the invoice and look at the amount of time on the invoice. The HSE should only be recovering their reasonable expenses, so look at the amount of time and also, if you feel strongly, dispute with them the amount of time they've spent on it.
Super. Okay, thank you, Andrew. I mean, one thing's clear, this is going to continue. So until next time, thank you.
Thank you.